Hello, everyone. Welcome to the Edfield Law Podcast. This is your everyday law podcast. We're here today once again. We have an interesting topic to discuss. A lot of times in society, most of us are engaged in one form of employment or the other. So today's topic seeks to highlight the importance of establishing an employer and an employee relationship and all the rights that would accrue to all the parties and all the obligations as well. So I have here with me Alberta. Alberta, how are you doing?
I'm okay. How are you?
I'm fine. I have here Prince. Prince, are you fine?
Very fine.
Okay. And I also have Eunice. Eunice, are you good?
I'm great.
Okay. First of all, I'm very glad you guys have joined me here to have this intricate discussion. So let's begin this conversation this way. Is it relevant for there to be an employer or employee relationship, or is it relevant for a working relationship to be governed?
Yes, I think it's very important because it's an agreement or an arrangement, just like any other contract. When you agree to do something with someone, it is better to put it in writing and to spell out the duties and the rights that each party will have under the contract. So that in case something goes wrong, or even if something goes right, you would have a reference point. You would know the next step to take. And the law actually requires that you have an employment contract. It depends. If you would also need it to know whether you are an employer or, let's say, an independent contractor. Even though the law looks at the substance over the form, you would look at the contract itself to determine whether this person is an employer or an independent contractor. And that would tell the kind of rights that the person should have, or what kind of things should the employer do towards that person's work. So it's very important.
Yeah, to add to what Albi was saying, people say that human beings are more loyal to their interests. Just consider a scenario where you have asked me to do something for you. You told me on phone, and you know that there are no laws regulating whatever you and I have talked about. When it gets to the time you are supposed to pay me, you can tell me that you never told me anything like that. What would be my evidence? You see? And so, aside from contract of employment, we are supposed to construe that relationship as a typical human relationship that whatever we are doing, we are supposed to have evidence of. And whatever we are doing, we are supposed to also ensure that it conforms with certain principles in the society, one of which is the Constitution, which talks about employment, the right to work and earn salary and all that under good conditions and all that. There's the Labor Act, which defines how everybody is supposed to work as far as you are an employee, how that particular relationship or that employment is supposed to be stopped or terminated. So yes, we are humans. It is supposed to be regulated.
Okay, so if I understand everything that has been said so far, for the purposes of our viewers, it seems as though there are two classifications when it comes to the terms of engagement of a person. Albi mentioned contract or independent contractor, and you also mentioned an employee or an employment relationship. So Eunice, what is the distinction between an employee and an independent contractor?
Okay, with an employee, you usually govern the employee-employer relationship with a contract of employment. And usually the rights of an employee is quite different from the rights of an independent contractor. With an independent contractor, it's more like you are free, so you are not fully restricted as compared to an employee. Let's say I employ Albi as an employee. The rights of Albi is quite different from, let's say, Prince being an independent contractor. with an independent contractor, there's quite some flexibility. Do you get it? So
Okay.
it's not something that you are more like restricted. And
Okay.
even the rights of an employer towards an employee is quite different from the rights of an employer towards an independent contractor.
Okay. That's interesting.
Yeah. So you see, it will be more relatable if I give an example.
Go ahead.
So, for example, the AC in this room, if it is spoiled,
Yeah.
and you want someone to come and fix, to make business sense, you don't have to employ someone who will be on a monthly salary to always fix the AC. You need someone to come in, fix, and charge you.
Depending on when it's
Exactly.
faulty.
So at the time the person is contracted to come and fix the AC, that person is not an employee. The person is working independently, but is under a contract to fix it. So that is why what the person is doing is called a contract for service. The person is giving you a service, so the person becomes an independent contractor. In that regard, you give the person fees. You don't give the person salary.
Okay.
Some of them come, you don't take what we call pay, the pay as you earn tax.
Yeah.
What you do as a company is that you do what we call withholding tax. So you calculate the tax, you deduct from the person's fees, and then you give the person whatever is left. And then you go and pay that particular amount called withholding tax to GRA. You don't pay the person any Senate contribution. I mean, you don't pay contributions on that person's behalf. So there are small things that you put together, one of which is you don't even determine when the person has to come to work. But here we are employees. You're supposed to come 8:30. If it's not 5, you are not leaving.
Yeah.
But the person who is coming to fix your AC, if he will use 30 minutes to fix the AC, what is he doing here? He finishes, he leaves. So those distinctions are very, very clear and very important.
Okay. So, advisedly, you are saying that if a person is being required to perform a service, right? From the standpoint of the employer, if that service is sort of temporary, then it makes sense to go for an independent contractor. I'm saying this because I want us to zone into the specifics. If you say someone is an employee, what are the specific circumstances that would govern the relationship to say this is an employment relationship? I think you established that of an independent contractor, where clearly there's no control.
Yes.
The person must not have a reporting time and the likes. So, what are the specifics when it comes to an employment relationship? What would determine that a relationship is that of service?
I think it's basically the opposite of what Prince said. So I'd give another example of people who provide lunch to offices or feed the feeding policy in certain offices. So, for example, a person may, let's say you have a vendor, somebody who sells food, and you have an arrangement with a person. You actually have a contract to provide a number of packs of food every day for your employees.
Yeah.
That person is an independent contractor because that is her own business.
Yeah.
She's allowed to work for other people. She's allowed to do he or she. Let me say he or she before. He or she is allowed to cook for other people. The person is not under your control. You don't determine. You don't even know where the person gets their stuff from, the things they used to cook. But that's an independent contractor. But that kind of person will be an employee where, for example, I know some offices have a kitchen, not the kind of kitchen where they bring the food and you go and eat. They actually have a kitchen for cooking.
Yourself.
No, they employ someone. Yeah. So the person is there 24/7, or not 24/7, but during working hours. So the person is there to cook breakfast for the employees. When it's lunchtime. So the person is there cooking every day. The company will definitely provide the funds for the person to, let's say, go to the markets and get the. But then the person But then the person is supposed to have like a salary. So ordinarily they will pay the person an amount of money every month. Okay, so that's in that situation, you would have to look at it. It's not, how do you put it? It's not straightforward that automatically somebody who repairs air conditions is an independent contractor, or someone who, yes, there are some offices, due to the nature of the work they do, they may require someone who is there all the time to service the ACs. Maybe they use it 24/7, or they are also into that kind of thing. So they have one of their own whose duty is to make sure that all the ACs are working properly and all that. So for every situation, you have to look at the elements. You would have to look at what is on the ground. It doesn't matter that in our contracts, you state that I'm an independent contractor, so you don't pay my SNIT and all of that. But if we look at what is going on, you are paying me a salary. I'm here all the time. You determine when I do what. You provide the
conditions.
Yes, the equipment for me to work. Then, obviously, I'm an employee, and then you have to pay.
You know, Alberta makes a very important point, such that what makes a working relationship that of an employment or that of an independent contractor is determined or should be determined by the specific circumstances. You realize that a lot of times what the person is doing has the characteristics or the element of an employment relationship.
But in the contract,
they'll say the person is an independent contractor just to maybe exploit or something. So I'm glad that we've all given the necessary classifications to distinguish one from the other. And the important point we must all take out of this is the fact that whether a relationship is that of an employment relationship or an independent contractor is determined by the circumstances itself. So if your boss is making you do certain things and at the end of the day he wants to classify you as an independent contractor, then you must be worried. You must be worried.
And to add to that, one thing we've observed over the years is that certain employers categorize people under that independent contractor relationship just to swerve certain responsibilities, like the SNIC contribution. Because they know that if you are an independent contractor, you are not an employee for your contributions to be paid. And you know that most independent contractors, especially the musicians who always go around to play shows, they will tell you that I will go and pay my own tax. So calculate the tax, put it on the fee I am charging, and then I will go and pay and bring you a receipt. So the companies don't want to, one, always go and declare to GRA that, okay, this person has worked with us for so and so months or years, and we are paying the person so and so. So GRA will calculate and say that you are supposed to give me this payee. Or Senate will come and chase them that you are not paying the SNIC contributions of these people. So these are some of the few things that people use to swerve responsibility. I think it's very good that we've clarified that.
And just to add to what Prince said, I think that's why it's very necessary that as an employer, as part of your responsibility or your obligation towards a worker, you need to provide that person with a contract of employment, at least to inform that person as to his or her rights and rights. Because on the ground, you might present to the person that this is what you are actually going to be doing. But inferring from the contract, it will be a whole different ball game altogether.
So hold on. Is that requirement statutory?
It is.
It's statutory.
It is. The law requires that if you are going to employ a person for a period of 6 months or more, it's advisable that you furnish the person with a contract of employment.
Not a letter.
Exactly, not a letter.
People just give you an appointment letter. You've been appointed as so and so. This is your salary.
Most of the time, contract of employment, which is detailed enough, at least to let the person know what his or her employment is about.
And I'd like to add that in some circumstances, there's a letter, right, stating just your salary. But then there's a policy. Sometimes it will refer to a policy or an additional document, which you may never receive.
Exactly.
That document is the one that is supposed to tell you all your rights and responsibilities.
Yes.
So if you are giving a letter push for them to give you that other document so that you don't finish signing before they bring it and you realize that, oh, you're supposed to do this and you're supposed to do that.
So on the discussion, what are some of the things I should look out for or we should look out for in an employment contract? We should talk about some of the seminal things which must be in an employment contract. So what are some of them?
Personally, if you give me a contract, the thing I will look out for first is the number of working hours.
Not
very important, please.
But what if you are working for like 8 hours and they are paying you 100?
Oh, the pay will come, but the first thing that I would look out for is the number of working hours.
Why is that relevant?
Oh, it's very necessary because even under the Labour Act, there is a maximum number of hours that a person is required. Yeah. Unless maybe you want me to stay for longer hours and you are paying me overtime or something. Okay. So it's very necessary. You can't tell me that, I should be in the office 24 hours when there is the need to fine. But at least, and what I will be said to, the pay is very important. So I'll leave that to her. She's more interested in the
working hours, the salary,
the scope of work.
Exactly.
You see, I get very emotional about that because unemployment rate keeps going up. And people who have the resources and the advantage to employ people are taking advantage of that. That, if you won't do it, another person will come. So they will discuss with you that, you are going to polish this shoe, iron this shirt, and then clean this, say, glasses.
Yeah.
That is what you are supposed to do.
Yeah.
A contract of employment will come and you are supposed to cook. You are supposed to brush someone's hair. You are supposed to brush someone's teeth, lay a bed. So you see, it goes beyond the scope that you agreed.
Yes.
And so, a normal circumstance, those extra ones would have fallen outside your contract, which you were supposed to be remunerated for.
Yeah.
But you go and sign because you are too excited. People don't look at the scope of work, their responsibilities. And I think it's one of the most important things anyone should look out for when you have a contract of employment.
Yeah. And even with the scope, some employers almost always, they would find a way, right? I've seen employment contracts where the scope is set. Then there's a further clause which will say that
any other
incidental things.
Reasonably.
As to what those incidental things are. So you realize that once you actually start working, then they would start assigning things outside the scope of engagement. And once you raise any issue, then they want to rely on the fact that, but as the contract said, apart from the scope, you are required to do any other incidental things which may be required of you.
It's just, you see, there's just a simple answer I'll give to that. When someone says that, I want pets, and then you ask, what kind of pets do you want? And you say, cat, dogs, and any other animal. The any other animal does not include a snake.
Yeah.
Because of the group of animals you started, or the types of animals you started mentioning. So if you have employed me as a secretary, administrative secretary, you say, I'll do printing, I'll receive correspondence, I'll do this, and then the last one is any other incidental things or any other thing in relation to the work. Which secretary cooks?
So that's a matter of
they send you to go and buy a watchy or something.
Coffee broke man. they will send you, go and buy this, go and buy that, come to my house to come and wash this. Oh yes.
Oh, people do that.
Come and wash this for me. You don't go. Do you know that you are supposed to do any other thing that is associated with the work? You say, I am sorry, it means that you are at fault, you are fired. So you construe it in line and consistently with those things that were first mentioned. That's why I'm saying that it is very important that you look at the scope, you ask questions. Don't be excited that you've gotten a job, because it's not everything that is polished that is good, right?
Yeah.
You may think it is an employment that is giving you an amount that you were not expecting, but at the end of the month, you go and use that same amount of money to buy drugs.
Yes.
And even just to, I think the place of work too is very important. Some take that out, thinking, oh, you'll be in Accra. You end up being in Takwa or somewhere, something that you did not plan to.
Yeah.
So other things that you should look out for as well is something like leave days, right?
Yes.
And then the working conditions, whether it's a safe, sound environment where you can work in.
Yeah.
And sometimes I've seen a lot of absurd things. I once saw a contract of employment where the contract sought to exclude vicarious liability.
How?
As in, it was in the contract that
They are
any
not
injury,
responsible.
whether during the course of
Really?
performing
Was it
your
the
functions
extent
or
or
outside the course of performing your functions, the employer is not liable.
Okay.
Yes. So let's address the point on vicarious liability. How does it operate, and who does it protect, and under what circumstances does it protect the parties?
So, for the purpose of our viewers, we are supposed to explain what vicarious
Vicarious
liability is.
Yeah.
That is where a third party gets injured or a third party has a claim against a company because the company's employee did something
Yes.
to that third party.
Yes.
So, for example, company A has employed Derek. Derek uses company A's car to go and hit Eunice.
Yeah.
So Eunice can go and sue company A, and that is what is the vicarious liability.
Yes.
Now, some of the clauses, see, they don't want us to say it, but it's true. Some of the clauses are just copied online,
Yes.
especially those who don't want to come and employ lawyers to go to
Yes.
them or draft. They will go, because I've seen a contract that they've said the applicable law is Chinese law.
When it's a Ghanaian company.
The person is here. The company is here. I believe pay, and then the person is employing Chinese law. Yes. You copy the same thing, you put it on Google, and then it will show up sample XYZ contracts. Yes. So you see, people copy things without necessarily knowing their legal implications. People also deliberately do them so that when something happens, they will insulate themselves and say, hey, this guy is working alone. And so, but the position of the law is that if you employ someone and the person is working in the ordinary course of the work you give him. So, for example, if you employ someone as a driver, the person is supposed to take deliveries from Circle every time. On his way to Circle to go and pick the items, he hits someone.
One thing happened.
And then you come to say that because he hit the person and not necessarily the company's director or something, then the company will not pay.
shouldn't be- Yeah.
That becomes illegal.
And also generally you cannot, if parties agree under a contract and the specific terms they've agreed on contravenes statutes, the term would not even be enforceable.
Exactly.
So let's stop drafting employment contracts and seek to exclude vicarious liability. But in everything, I like to take it from two sides. It's like we are bashing the employers too much. So on vicarious liability, it also doesn't mean that, with the example you gave, if you are contracted to or if you are assigned to take deliveries of things from Circle every day and you've gone to hit someone at Navrongo, that's clearly outside the scope of your work. So under those circumstances, then the employer wouldn't be liable because nobody has sent you there. Okay, so staying on what the employees are also supposed to do, it seems we've had lengthy discussions with respect to what the employer must do. What are also some of the obligations of the employees as well?
So you are employed for a certain purpose. You are employed because something needs to be done. So it is your duty to do that thing and do that thing well. That is why the employer is allowed to, terminate your employment at any time. If the employer thinks that the reason for which you are being employed, you are not able to do it, you are incompetent and all that, they can terminate your employment. So it is something that you must do. You should also protect the assets of the company. That you should work for the interests of the company. So you realize that in most employment contracts, they would say that upon termination, whatever property you have, so if the company gave you a phone, a car,
Have to
a
return
laptop,
it.
you have to return it. So you have to return it the way they give it to you.
Yeah.
Yeah, so that's another duty that
And
lies on the
also-
employee.
Please, very important. Required to come to work regularly and punctually. Very important. I think in our part of the world, we usually play that role very lightly. Like we don't take it into much consideration, but it's very important.
Where that even if you are going to be absent for whatever reason,
Exactly.
at least notify your employer
Exactly.
with those stated reasons. And in rounding up, let's round up by talking about termination, okay? Because clearly, if an employee or an employer, they breach some of their obligations under the employment agreement, then termination is the obvious consequence. So people are seen to have sold their souls. There are a lot of people out there who are engaged to work for people,
You can't
and in their minds they think, okay, they cannot stop working for them. What does the law really say on termination?
So the first point everybody should get is that not every contract of employment will specify the number of years you are supposed to work for the person.
Okay.
But like a Supreme Court judge said, it does not mean that you've been employed for a lifetime,
Yeah.
that you work till you die.
Yeah.
That's how some people think. Contract of employment is a contract between two people, one of whom is asking for a service and the other giving the service. At the point where one says that the one asking for the service says that I don't need it anymore, it can be stopped and it's lawful.
Okay.
At the point the person who is giving the service, which is the employee, thinks that someone will say, I'm not going to do again. it has to stop, right?
Yeah.
So the termination can be done by either party. Just that there are certain regulatory compliance. There are certain terms in the contract that when you are terminating, you are supposed to look at and conform
Yeah.
to those rules.
Yeah.
If your contract of employment is saying that before the contract is terminated, you are supposed to be giving, say, 1 month notice, or in lieu of that, you're supposed to be giving 1 month's salary. They can't say you are fired, go home, and nothing. When they do that, that termination becomes unlawful. And that's what we call wrongful dismissal.
Right.
Because the two of you agreed how you should stop your relationship,
Yes.
and you've gone contrary to that. So when the person takes you to court, it is not only the 1 month salary in lieu of notice that the person will get.
Okay.
The person can claim damages or tell the court that he wants compensation for you terminating that agreement wrongly.
Okay. So, granted that both parties can terminate, right?
Yes.
So, we should treat it like an open door. The same way they voluntarily entered the contract,
Yes.
they should be able to voluntarily leave the contract if they wish to do so.
Absolutely.
Does it mean they must give reasons for termination?
There's no law that says that you should give reasons when you are terminating. However, there is a requirement
Yeah.
that if you choose, the law says you are not supposed to give reasons. You can decide not to give. You can decide to give.
Okay.
But if you decide to give a reason, the reason should be fair.
Okay.
And that is where the reason given, if it's not fair, then it becomes another way of going contrary to law, which is called unfair termination.
Okay.
So, for example, you have gone to terminate someone's contract because a person has joined TEU
Yes.
or UTAG,
Yes.
or the person has run for elections and the person wants to be a secretary of UTAG, and you
Yeah.
think that when the person wins that election,
Yes.
demonstrations, yay.
Yes.
So you terminate. That becomes unfair termination.
Yes.
What really happens to a lot of women, they marry and then people start treating them as if they've changed. Their competence has changed. And it's even worse when they get pregnant.
That's very unfortunate.
Yes. And then you terminate because the person has gotten married or the person is pregnant.
Yes.
That becomes unlawful or unfair termination.
Yes.
But there is also a situation where you do a lot of things, a lot of bad things to the employee. The employee comes to complain to you.
Yeah.
You don't do anything about it. And then based on that, the person says that I won't work for you again. The person rather voluntarily says, I have stopped working for you. The law construes that as a constructive dismissal of that person.
Yes.
So what it means is that your act, those bad things you did to the person, force the person to stop working. And so in that scenario, there are two different things the court can do to you, the employer.
Okay.
One is that you can be forced to give the person a different work or reinstate the person.
Yes.
That this is what you did. Make sure that all the things the person was complaining about, which are legitimate, you stop or you remedy them, but reinstate the person.
Yes.
Or if the law looks at the situation and realizes that, oh, this relationship, there's no way they can work again.
Yeah.
Yes.
Sexual harassment here and there, and then she can't really work without, focusing. See, you can't reinstate the person. In that circumstance, you have to pay compensation.
Compensation.
So that is a difference that I think we should all get.
Okay. We have to come to the end of the discussion, and thank you guys very much for joining us. We've spoken about a very important subject matter in society, where we've outlined why it is important to have a sort of contract governing your employment relationship, and why it is important to look out for the terms. First of all, get a lawyer to draft every employment relationship, because if you go and download all those clauses from the internet and it's contrary to the statutes in Ghana, it would not be enforced by the courts. So thank you for joining us once again. We'll see you on our next episode, and don't forget to follow us on all our social media handles. The respective handles shall be displayed on the screen, or is displayed on the screen. Thank you very much.